Hi, everyone, and welcome to our channel. My name's Greg Smith. I work at Commons Commons LLP. We're a law firm based in Philadelphia, PA, with 5 attorneys. Our trust and estates practice has served families in the Philadelphia area, including southern New Jersey, since 1973. Additionally, we have a practice area dedicated to serving independent schools and heads of independent schools. That head of school and independent school practice is the focus of this presentation, and in particular, we're talking about the negotiation between the school and the head over the head of school's employment agreement. That could be a new head coming in or renegotiation of or renewal of the existing head's contract. Although I am not one of the attorneys at the firm, I am a chartered financial analyst and I work on client matters in that capacity. Now, let me tell you a bit about Pete, who is our practice lead in the area of head of school and independent school matters. Okay, so about Pete. Pete Commons is the attorney leading our work with independent schools. Pete serves as general counsel to independent schools, and he represents heads of school in negotiating employment agreements and advising on leadership issues. With extensive experience, Pete has negotiated hundreds of contracts on behalf of both schools and heads, making him a recognized expert in this field. Pete's also a sought-after speaker, regularly addressing school groups, heads of school, and board members on leadership and contract matters. He holds a law degree from Temple University's Beasley School of Law and a BA from Middlebury College. In addition to his legal practice, Pete is committed to the education community, serving on several nonprofit boards, including the Germantown Relief Society and Aubrey Arboretum, and previously chaired the board of the Mequon School in the Philadelphia area. Pete is admitted to practice law in Pennsylvania and New York, and we are proud to have him leading our efforts in supporting independent schools. Pete's father, Hal, really started our head of school and independent school practice, mostly providing counsel to schools in the Philadelphia area. So the firm's history in this space is a long one. After Pete absorbed Hal's wisdom and took the head of school and school matters over from his father, it really became Pete's focus, so much so that he now works almost exclusively on school and head of school matters. And he does this on a national basis with clients in California, Massachusetts, and everywhere in between, including some clients overseas as well. All right, let's get into an agenda for today's discussion. We already covered about Pete, so we'll start with the strategic basics to kick off the negotiation process, including how to effectively utilize your lawyer. Then we'll dive into the key terms that should be included in the head of school contracts. We'll also touch on the IRS's interest in head compensation and explain the complexities of deferred compensation. Throughout the presentation, we'll pause for questions to ensure everyone's on the same page. Before we proceed, I must emphasize this disclaimer. This presentation is designed for educational purposes only and does not constitute legal or financial advice. Each school and head should seek specific legal counsel for their unique situation. And remember, the information presented here is subject to change, may become outdated quickly, and so always consult with your own attorney for the most current advice. All right, let's get into the thick of it here. When negotiating the head of school agreement, it's crucial to remember the principle. Don't let perfect be the enemy of good. And here's why. Number one, relationship with the board. The head has to work closely with the board throughout their tenure. An adversarial stance during negotiations can damage this relationship. Instead, aim for a collaborative approach that fosters mutual respect and understanding. Number two, the lawyer's role. If the head has retained a lawyer, it's important that the head remains in control of the negotiation process. The lawyer should act as an advisor rather than the primary negotiator. The head should determine which asks feel appropriate and ensure that the lawyer's actions align with their comfort level and goals. Number three, remember that once the contract is signed, the lawyer's role typically concludes, but the head's relationship with the board is just beginning. So it's vital to set that positive tone during negotiations to ensure a smooth working relationship moving forward. 4, seeking a balanced agreement. While it's important not to concede too much, the goal should be a balanced agreement that manages the relationship and offers financial advantages. A well-negotiated agreement can positively influence the head's overall experience and performance at the school. 5, the board's perspective. Now, the board will be observing how the head handles negotiations to gauge their approach to other school matters. Demonstrating seriousness and professionalism in negotiations can instill confidence in the board about the head's capabilities. Lastly, avoiding regret. The head should aim to be a reasonable counterparty, ensuring that the school does not start wishing for a different head due to a contentious negotiation process. The objective is to secure an agreement that both parties can agree upon without damaging future interactions. Again, don't let perfect be the enemy of the good. All right, now how do you start the negotiation? What's the way to begin? So here are a few key strategies for the heads to consider at the very beginning of the negotiation process. Number 1, the non-negotiables. If you're the head, understand what would lead you to walk away from the negotiation table. But keep this information to yourself. This clarity will guide your decision making throughout the process. Number 2, recognize minor issues. Don't walk away over minor issues that shouldn't be deal breakers. It's important to distinguish between what's essential and what's negotiable. 3, recognize the school's incentives. Schools have strong incentives to agree to reasonable requests. These include the time and money required to conduct a new head search if the negotiation goes poorly, and the risk of hiring an unknown replacement. And again, the burden of transition on the organization and its leadership when the head changes. Finally, reasonable requests. By focusing on reasonable requests, you can leverage these incentives to your advantage, ensuring a smoother negotiation process and a more favorable outcome. All right, so more about your thought process at the beginning of the negotiation. Binding agreement. The agreement should bind the head and school in law and spirit, fostering a collaborative and supportive relationship. So that includes things like avoiding aggressive or bitter conversations. Compensation should be high enough to make the head happy to work at the school. Termination provisions should be reasonable while allowing the school some outs, and parties should sign as friends. What should happen? The school should ask the head what they want before drafting the agreement, and a general conversation should occur over a couple of weeks. What typically happens, on the other hand, is the school hires a lawyer who prepares a defensive agreement, defensive as in, in the favor of the school, without a serious conversation with the head. The head then has to raise concerns with the help of their own lawyer, who ironically is often paid by the same school as a benefit of the final agreement. Of course, as a law firm, it's in our interest to say this, but it really is quite common for the school to pay all or at least a substantial part of the head's legal fees from the negotiation. So it's something to keep in mind, and it's definitely what we see is happening in the market. All right, so speaking of lawyers and lawyers' fees, let's cover why the head should use a lawyer. Really, hiring a lawyer can be incredibly beneficial for several reasons. 1, support and feedback. A lawyer provides moral support, legal support, honest feedback, and this is invaluable during negotiations. 2, managing the negotiation. The lawyer can manage the negotiation process, allowing the head to focus on their current job. This is particularly useful if the negotiation becomes emotionally taxing. 3, direct negotiation. Most heads prefer to negotiate directly with the board chair, with the lawyer providing coaching in the background. This approach maintains a personal touch while ensuring legal expertise is available. However, there are times when allowing the lawyer to take a direct role in the negotiation can be beneficial, usually reserved for those times when the negotiation starts to become heated or looks like it might become emotionally charged or taxing. A scapegoat. If the negotiation turns sour, the lawyer can act as a scapegoat, deflecting potential blame from the head. This is actually a serious benefit of using an attorney in this kind of negotiation. Lastly, as I mentioned before, attorney's fees, more often than not, the schools are covering the head's attorney's fees, sometimes with a limit. But in any case, it's important to clarify early on who will cover the cost of the lawyer in order to avoid any misunderstandings or disputes later. All right, right before we go to the major items or line items in a head contract, I want to discuss how the head should use their lawyer for maximum effectiveness. So, number one, retain a lawyer early in the process. Two, ask your lawyer to develop an approach and a time frame for the negotiation. Three, tell the lawyer if you don't like the proposed approach or style. It's important that the head remain in control. Three, sometimes lawyers can be relied on to do things the head would like to avoid. So, for example, compensation analysis. Compensation analysis is something we do at Commons and Commons that is really at the core of the value that we provide to our clients in a head of school negotiation. Negotiating sensitive items like those around termination. Educating the school on the process and what is market or typical terms. And being able to say no on the basis of legal risk. The lawyer can provide cover for you when you want to say no to something. My lawyer advises against this, that this would expose me to too much risk. What negotiating the head does directly versus what is handled by the attorney is kind of a critical topic of the dialogue between the head and the attorney, and the optimum strategy really varies and is dependent on the particular situation and the personalities involved. So that's not only the personality of the head and the lawyer, but also the personalities of the entire cast of characters that gets involved in the head of school employee negotiation and approval of the final contract. So now that we've covered how and why to use an attorney through this process, let's discuss the actual head of school employment contract itself. What terms are usually in it, how to think about each term in a typical negotiation. Now we're going to go through each of these in some detail on later slides, so I'm primarily going to just enumerate them here. One, base salary, obviously a fundamental component of compensation. Two, bonuses and increases, so that's additional compensation based on performance and other criteria. Deferred compensation, future benefits contingent on continued employment. This is usually good for heads from a tax perspective and good for schools in that the deferred comp incentivizes the head to stay long term in order for the deferred comp to vest. Number four, we have housing or a housing allowance. Whether the school provides housing or a stipend for housing, this can be a big issue for head negotiations, and how the housing's provided can have significant tax consequences that both the head and the school need to be aware of. Five, the contract term or the duration of the agreement. Usually these are 3 and 5 year agreements, sometimes less, sometimes more. There is too short and there is too long in our opinion, which we will discuss later. 6, early termination or resignation conditions. So these are conditions under which either the school or the head can end the contract prematurely. 7, standard and supplemental benefits. These are items like retirement, health, life insurance, disability insurance, things of that nature. And then lastly, we have other perquisites such as automobile allowance, club memberships, travel, sabbaticals, and reimbursement or payment for professional development. So in order for the negotiation process to proceed smoothly, typically all of these key terms should be largely settled before drafting of the formal employment agreement begins. And this is usually done in the form of a non-binding term sheet agreed between the head and the school. The school is usually represented by the board chair. Now, we usually call this non-binding agreement a term sheet, but it goes by other names as well. So term sheet, letter of intent, memorandum of understanding, and proposal are all basically used interchangeably for this stage in the negotiation. All right, let's go through some of these line items in a little more detail here. Let's start with term and renewal. So what we see in the market is typically these terms are 3 to 5 years, 5 being kind of the maximum, and 3 really is what our firm has keyed in on as probably the ideal balance between the school and the head, and the both parties' desire for security, but also both parties' need for a periodic renegotiation to protect their mutual interests. Responsibilities and restrictions. The contract will clearly outline the head's duties and any restrictions. So whether or not they can, for example, pursue consulting engagements on the side and things of that nature would usually be addressed in a section on the roles and responsibilities of the head. Housing provisions. This section should detail any housing allowance or school-owned housing arrangements and note specifically the tax implications for the head. I think we may touch on this later in the presentation, but basically if the school is able to provide head housing on campus, that is typically the best. And if they have to provide housing off campus, it will be a taxable benefit to the head, and there will probably be some negotiation about around whether the head should get a gross up payment to cover the taxes on the housing benefit and the taxes on the gross up itself. Base salary and increases. Specify the initial salary and how it will increase over time, whether automatically or at the board's discretion. Bonuses. Determine if bonuses will be at the board's discretion and whether a target bonus will be stated. So you can think of a target bonus as, the expected bonus for the head. If the contract has a target bonus and the board elects to pay them less than that target bonus in a given year, that's a signal from the board that either the school is not performing as financially well as expected, and or the head themselves is not performing as expected. Vacation and insurance. So there's a need to define the vacation time and insurance benefits, including life and disability. Typically, we see vacation, at least if the school is making the proposal, of somewhere between 4 and 6 weeks. And medical insurance is almost always included, or at least participation in the group medical plan that the school has is always included. And then there's usually some negotiation around supplemental life and disability insurance as well. They are very commonly included in a head of school contract. Tuition remission. A lot of heads have or will have school-aged children that they'll want to attend the school, and tuition remission is generally included in a head's contract. So there's usually two components of it. One is a non-taxable benefit, usually referred to as tuition remission. And that is the benefit the head receives towards tuition that is part of the school's standard tuition remission benefit that's provided to other faculty. And then there's a taxable tuition benefit, which is the extent to which the head receives a tuition benefit that's over and above that typically provided to faculty. So, for example, you might see that the school ordinarily provides 50% tuition remission as a general policy to faculty, but the head is given full tuition remission, and that really is kind of two separate benefits, because the half that is untaxable and the other half is taxable to the head. And again, like all these taxable benefits, there's some negotiation as to whether the head will get a gross up to cover the tax liability. Lastly, on this slide, we have retirement plans and deferred compensation. So usually there's a group retirement plan. It's 403B, and there's some matching involved where the school will match head contributions to the 403B plan. And then typically separately detailed is going to be deferred compensation arrangements, such as 457B and 457F. And those are quite complicated, but we are going to go into those in some detail on a later slide. So some more key features. One would be an automobile allowance or a leased car for the head to use. Not super common, but we often do see a automobile allowance as part of a compensation package, and it usually works best for both parties for this to be done basically as an allowance of a reimbursement to the head towards their automobile costs. Cell phones, the agreement should, spell out who owns the phone and pays for the plan and has access to text messages and the like. It's advisable for most heads to have their own cell phone and either pay for the plan themselves or have the school just reimburse them for the plan. Is usually what works best for both parties. Termination provisions. So there's a need to define the conditions for termination by the school. Usually we have for cause and without cause, and definitions of what it is that would be cause for the school to terminate. And for the head, with good reason and without good reason. And the item that's up for grabs based on whether the termination is for cause or for good reason is a severance. That is what is at stake, given these differences. Indemnification. Head should be indemnified for taking actions in good faith on behalf of the school. A head shouldn't be held personally liable for the decisions they make as a head unless the school is able to to prove that they're, acting negligently or criminally. As long as the head is acting in good faith, the school should be taking on the responsibility for liability that comes from the activities of the school. Insurance: school should maintain appropriate directors and officers insurance. Outside activities: this is going to be addressing, this goes back to the roles and responsibilities section. There should be some effort to address permission and compensation for outside activities like board service or consulting. And then lastly, here we have post-employment restrictions. These are things like non-solicitation, non-compete, privacy, intellectual property ownership, return of school property, and non-disclosure of confidential data. You'll see terms addressing each of these in a head employment contract. Clear articulation of all these terms ensures both parties understand their rights and obligations. Let's talk for a minute about annual performance evaluation, which is something that should be written into any good head of school employment agreement. But whether written in or not, they should certainly happen. So the annual performance evaluation, the head should seek to encourage focus on the most important issues, provide constructive feedback to the head directed towards future performance and growth, foster a spirit of communication between the head and the board on key issues, and perhaps inform compensation. So remember, there's bonuses and annual increases, for example, that are typically left to the discretion of the board. Obviously, a annual performance evaluation is going to inform such discretion. Evaluations of the head should also happen annually. They should be sustainable, so they should be not too demanding on the head or the board to be, comfortably repeated each year. They should be performed by the board or a subcommittee of the board and led by the board chair. They should be used to establish mutually agreed upon goals on which the head should be evaluated in the following year and be documented for future reference. And again, like I said, it should be the basis for salary increases and or performance bonus payments. All right, let's talk about how compensation negotiation should be informed by peer data. It is important for heads to advocate for their talents and for schools to offer reasonable compensation in order to attract quality candidates for the most critical leadership position at the school, and to incentivize good performance and long service. Heads should conduct independent research on peer schools or seek help from their attorney, school's business office, or national or state associations. NAIS, the National Association of Independent Schools, provides perhaps the best source of data for this sort of research, but head compensation is also available publicly, though with a considerable lag, from the school's annual tax filings, which are available for most schools that are not religiously affiliated. In a data-based negotiation, the two things negotiated over most are: one, what makes the most appropriate peer group for the analysis, and two, given the selected peer group, what is the appropriate percentile within that group to target for the head's base salary and total compensation. We, of course, take quite a bit of pride at Commons and Commons for our abilities in selecting and researching peer groups that are both favorable from the head's perspective, but also reasonable from the school's perspective. With regards to target percentile, I think it's commonplace in the market now to use the 75th percentile as the baseline or default percentile to target. That said, what's appropriate for a particular negotiation and where the negotiation is likely to end up is affected by such things as the head's level of experience and qualifications, the board's perception of risk that the head will leave for better compensation somewhere else. If the negotiation's a renewal or existing head's contract, then of an existing head's contract, then the board's satisfaction with the head's performance to date is obviously an important factor, as is the board's perception of the availability of qualified head candidates should they have the unfortunate need to search for a new head. So, a common approach to a non adversarial negotiation is to pin the compensation to these factors before actual numbers are broached. This turns the focus to what constitutes a peer group, appropriate peer group, and relative performance and institutional qualities rather than raw salary numbers. And that really helps take the tension out of the negotiation. Now, believe it or not, the IRS actually cares about head of school compensation. Most heads work for a 501c3 nonprofit to which contributions get special treatment under the Internal Revenue Code. Head's compensation package must be reasonable when compared to other heads at like schools in order for the IRS to consider the compensation to not be excessive. If a school provides excessive compensation, it may be conferring prohibited private benefit and private annulment, contrary to Section 501c3 of the Code. Now, the way schools deal with this, or the way schools should be dealing with this, of course, is to obtain their own independent comparable data on compensation at peer schools. This is actually required by IRC 4958, Internal Revenue Code 4958, and document this data at an appropriate meeting of the board or applicable committee of the board without any interested persons present. An interested person would include the head's spouse, head's lawyer, among others. Now, one strategy for this is to employ a law firm to prepare something known as a safe harbor letter, which provides an extra level of protection against the IRS making a charge that head compensation is unreasonable. All right. Hiring an experienced attorney in this field to prepare a safe harbor letter is highly recommended, and here's why. If the IRS finds the compensation of the head to be unreasonably high, the consequences can be severe. First, they're likely to impose what are known as intermediate sanctions, as in sanctions imposed instead of revoking or before revoking the school's 501(c)(3) status. These would include a 25% excise tax on the excess benefit imposed on the head of school and potentially increasing to 200% if not corrected in a timely fashion. And the school itself may face a 10% excise tax due to knowing participation in the provision of an excess benefit. Of course, if the head and the school do not pay the excise taxes and remedy the situation, the IRS could simply revoke the school's 501(c)(3) status, which would be highly detrimental to the school. Now, it's important to appreciate that schools can compensate above, even well above, the 50th percentile of their peers if it's appropriate for them to do so. However, they absolutely need to document the basis for doing so. As I've mentioned, the best way for schools to do this documentation, especially those paying towards the top of their peers, is with a safe harbor letter prepared by a qualified firm. This is something we do regularly at Commons Commons. It's not something we can do for schools in cases where we represent the head, but in any negotiation where someone else is representing the head or the head lacks their own representation, this is certainly a service we can provide. Now, with or without the safe harbor letter, proper documentation and justification of the head of school compensation package is the key to avoiding these penalties. If there's any concern that the IRS may determine the head's compensation is out of the norm, boards really need to dot their I's and cross their T's in documenting the basis for the compensation package. All right, let's talk about the data we might use for compensation research and benchmarking in order to set compensation for a head of school. There's really two primary sources that we rely on in the United States. One is the IRS, IRS Form 990 is the form that schools use for their tax filings and includes compensation data. And the other source is National Association of Independent Schools DASL database, which is available to NAS member schools. Now, the pros of the IRS data. Now, you can presume that the IRS data is probably a little bit more reliable and accurate than that reported to NAIS. The NAS data is this responses to a survey, and schools don't have to answer every question in the survey. They don't necessarily answer every question in the survey, and they don't really have to be all that accurate either. But you expect a certain amount of accuracy in filings to the IRS. The other thing that's a pro for the IRS 990 data is that you do see school level. You're pulling the IRS 990 for specific schools, and you're looking up what they pay their head at the school level, so you know which school is paying their what to their head. Cons about the 990s are they're typically 2 years out of date. The NAIS data is usually about 1 year out of date, so you're losing the benefit of a year. And the other major con with the 990 data is that religiously affiliated schools are often not obligated to file a 990. So Catholic schools, Quaker schools, it's often hard to put together a lot of data on them from 990s. Now, on the other hand, you have the NAIS DASL database. The primary pro of that database is just that it's more timely. You also get to see more details in terms of the line items that are reported in the NAIS database. And it's more efficient for us to research in the NAIS database than to pull 990 forms and try to extract data from them. There are some cons to the DASL data. So schools may not report to DASL as completely or as accurately as the IRS. Not all member schools report. So you may find, you have a peer group of, say, 10 schools or 15 schools, and only maybe, 7 out of 10 or 12 out of 15 are reporting the data that you hope to analyze. Lastly, unlike when you're researching 990s, you can't see school level peer compensation data. So you can't match the compensation up to specific schools. But you do get, for a large enough data set, you get the minimum, the maximum, the median, 10th, 25th, 75th, and 90th percentiles of compensation, which is pretty good. I mean, I would say if you have access to NAIS, these head of school negotiations are probably about as well informed by the data as possible for just about any chief executive negotiation imaginable. Now, process here is important, and not just to avoid IRS penalties, but also as a matter of plain good governance. It's really important that the compensation should be approved through a rigorous and well-documented process. Boards themselves should already be aware of this, but heads may underestimate the importance of the process to the board, and it's something heads should understand and appreciate. For starters, compensation package should be approved by the board or authorized committee, such as an executive committee, compensation committee, or an ad hoc committee set up specifically for that purpose. And there should be no conflicts of interest on the committee. The board should authorize the committee in a resolution and minutes in conformity with the bylaws of the school. Clarify if the committee has authority to finalize the deal or it needs final approval from the board at large. Of course, rely on comparable data of peer schools. And finally, document the basis for the decision and/or rely on a professional's written opinion as to the reasonableness of the compensation. This is the aforementioned safe harbor letter. Understanding this process helps heads appreciate the school's perspective and ensures compliance with IRS regulations. Let's move on now and talk in greater depth about the term of the agreement. Term is the longest period of time the head's employment can last under the agreement, not a guarantee or promise that it will last that long. Typically, the term is set to between 2 and 5 years in most agreements, with 3 years being the most common and, in our opinion, probably most optimal in most cases. This is just because 5 years is an awful long time without a negotiation. For a head, it means typically means falling behind the market in terms of compensation. And for a school, it's kind of a long time to be locked in without a chance to change course if things aren't working quite as well as expected. Termination provisions allow for sooner termination and determine whether and under what conditions there will be severance. So that's a key when we go back to termination with cause and without cause. Resignation with good reason, without good reason. It's the severance that's at stake. Compensation tends to increase significantly with each negotiation, so auto-renewal or evergreen provisions are typically not in the best interest of the head. Schools may like these because the force of inertia will enable them to keep ahead possibly for a long time with just sort of cost of living increases. But the market for head compensation is increasing a lot faster than inflation, so we would recommend against this sort of provision for heads. A new agreement, provides a reset. It's important. It's an opportunity to review updated comparable school compensation data. It's an opportunity to improve the target percentile for compensation. And a negotiation provides feedback on what is important for both the head and the school. So all those are reasons why we don't recommend auto renewal or evergreen provisions in the head of school contract. For most of their careers, heads should target 3-year agreements and then possibly pursue longer terms as they near retirement. This is the typical pattern. All right, now let's talk about termination provisions, which is another sensitive area of the negotiation and therefore one where having an attorney represent you is beneficial. Termination clauses are critical and should differentiate between termination without cause and termination with cause. Termination without cause. This should be termination for circumstances without egregious conduct. Severance is offered to the head, typically 6 to 18 months of salary upon release of all possible claims against the school. Termination with cause, on the other hand, is for egregious conduct or misconduct. No severance will be provided, and probable reputational consequences for both parties, particularly for the head. Usually we want to write an employment agreement that has a series of steps that need to happen in order for termination with cause to take place. And generally, we want the school and the head to negotiate a separation agreement that works for both parties. In cases where you might think you're headed towards termination with cause. So now it is common to see similar definitions regarding the condition under which a head may resign, usually stated as either with good reason, which would entitle the head to severance despite resigning, or without good reason, which obviously would not entitle the head to severance. Without any terms in regards to resignation, it's presumed that if the head resigns, the head foregoes any right to severance unless they're able to get the school to agree to such in a negotiated separation agreement. All right, more details on some of the other benefits commonly written into a head of school agreement, employment agreements. Tuition remission and additional tuition benefit. I touched on this before briefly. Remission equals the tuition remission program provided to a broad class of employees. This is a non-taxable benefit. Additional benefit or stipend is tuition benefit in excess of the standard remission, and it is a taxable benefit. This is often misunderstood by schools, and it's important to use specific contract terms. Head should seek conversion of tuition benefits to salary upon graduation of a child. That's kind of a biggie. And the head should seek a gross up on the taxable portion of the tuition benefit to make it tax neutral to the head. Supplemental life insurance, typically a $1 to $2 million term policy covering the head to age 65 is usually provided for. Supplemental long-term disability, typically replacing 60 to 70% of the head's salary. Spousal travel on school business is usually reimbursed. Sometimes you'll see a club membership. This is, especially in the event that a school is geographically close to a club that serves the same, clientele, if you will. Automobiles, consider allowance to reimburse head for the cost of car ownership, which allows for simpler insurance arrangements and personal family use, but it is taxable to the head. Alternatively, the school can lease or purchase a car for head use, and ideally the head should seek gross up for any taxable allowance or reimbursement, such as the automobile allowance. Now, housing. Housing's an interesting one. So housing's non-taxable to the head if provided, 1, on campus, 2, as a condition of employment, and 3, for the benefit and convenience of the school. The contract terms need to be carefully crafted to make the head's acceptance of employment conditional on the head living in the head's residence. So this is very important for schools that offer on-campus housing to the head. Otherwise, the housing benefit is going to be taxable to the head. And that could be a significant tax liability for the head. There's some opportunity for school to provide off-campus housing to head at a reduced but still adequate rent if the school owns an off-campus head's residence. A small tax-free benefit is created for the head if there's a difference between the adequate rent under IRS rules and an actual true market rent for a similar property. Head should seek a gross up for any taxable housing allowance or reimbursement. If housing is provided either on or off campus, typically major and routine repairs, maintenance, insurance, refurbishing, and house cleaning are all usually provided or reimbursed by the school, in addition to any rent or mortgage interest. Now, the bottom line on this slide is that if appropriate land exists on campus, it would be wise for the school to consider constructing a head residence. Without a doubt, it will improve the school's ability to attract and retain talented heads, which increasingly they need to do from a national pool of candidates. A head of school residence on campus makes this so much easier. A few more terms here before we finish up talking about deferred compensation. One is relocation costs. Relocation costs are commonly covered by schools to assist new heads with moving expenses. This can include the cost of hiring moving services, temporary housing, travel expenses, and other related costs. Clearly outlining what expenses are covered and up to what limit can help avoid any misunderstandings. Legal fees. It's common for schools to cover legal fees up to a specified limit. This benefit allows the head to seek professional assistance during their negotiation process without bearing the financial burden. Legal fees can include costs for reviewing and negotiating the employment contract and ensuring all terms are favorable and legally sound. Financial advisor and or professional tax preparation. This one's not particularly common. Some schools offer the services of a financial advisor or a professional tax preparer, but not many. These services can help the head manage their personal finances and navigate the complexities of their compensation package, including tax implications. The benefit can be especially valuable for heads with more complex financial situations. So, you do see this benefit with wealthier schools with higher compensation packages are going to sort of provide this alongside. Lastly, an executive coach. Providing access to an executive coach is an increasingly common benefit. I'm not sure I would say that's necessarily a benefit to the head so much as to the school, but in any case, a executive coaching arrangement can support the head's professional development, help them enhance their leadership skills, navigate challenging situations, and improve their overall effectiveness for the school. This investment in the head's growth benefits both the individual and the school and fosters a more capable and resilient leadership. Each of these benefits, of course, can be negotiated and should be clearly defined in the employment contract to ensure both the head and the school have a mutual understanding of the terms. These additional benefits not only make the overall compensation package more attractive, but also support the head's personal and professional well-being, contributing to their long-term success and satisfaction in their role. So here we're going to talk about deferred compensation, specifically 457F deferred compensation arrangements, also known as golden handcuffs. So usually only used if a 403B and 457B contributions are maxed out. So most schools will have a 403B program. Some will have a 457B benefit for the head. But what we're talking about here is larger deferred compensation arrangements that are not limited by the IRS, but have to be structured to conform to 457F rules. Sophisticated contribution and vesting terms are required in order to conform, so many school business offices have trouble administering 457F plans without error. And so basically, adding a 457F plan is a great way to add additional compensation, but it is going to add complexity to the negotiation for sure. Now, it needs a separate plan agreement, which will require additional negotiation and legal fees for both the head and the school. It must include a substantial risk of forfeiture, which means the head may never get the compensation if there's early termination. And it locks the head in for a longer term, hence being called golden handcuffs. It also creates a tax bomb at vesting because deferral for income tax purposes stops when the benefit vests. All these things, both parties need to be fully aware of if we're going to employ a deferred compensation arrangement as part of the compensation to the head. One last thing here that we don't always talk about, but is definitely a viable alternative, are loans. So loans can be an alternative to housing allowances or deferred compensation. Schools can provide loans with interest rates as low as the applicable federal rate to avoid creating a tax liability for the head. Creates a benefit to the extent that the set interest rate is lower than the head's cost of borrowing from a bank or other benefit. Forgiveness of the loan at some future date and under certain conditions would have similar effect as a deferred compensation arrangement. Loans to heads or any other related party are disclosed on IRS Form 990, which not all schools are comfortable with, but it's more common than you might expect. And, for the right head and the right school, it's something that maybe should be considered. All right, that's it for today's presentation. I want to thank you for watching and remind you to seek your own legal advice and not rely solely on this presentation. We did not have the benefit of knowing your specific situation in putting together this presentation. If you do want to discuss working with us, by all means, you can contact me or Pete directly. And thanks again for watching, and have a great day.